Bismillah ar-Rahman ar-Rahim. Assalamu alaikum wa rahmatullahi wa barakatuh. Introduction to Paralegalism, Perspectives, Problems, and Skills. 9th edition. Chapter 15, narrated by Omar Mohsen Ibrahim Fouad. Chapter 15, Informal and Formal Administrative Advocacy. Chapter Introduction. Chapter Objectives. After completing this chapter, you should be able to define advocacy, distinguish between informal and formal advocacy, list the major techniques of informal advocacy, justify the importance of timing, evaluation, adaptation, and record keeping in advocacy, list the major components of procedural due process, explain when the paralegal is allowed to represent clients at an administrative hearing, identify differences between federal and state administrative process, discover how rulemaking procedures affect advocacy in the administrative process. What if you decide that it was time to leave your law firm and strike out on your own, start a new business? Over the past 5 years, you have worked with an attorney who primarily worked on Social Security cases where you assisted in preparing cases that would be heard before the administrative court. You always sat second chair and never appeared directly before the administrative hearing officer. Even though you did all the prep work for the cases, including interviewing the client and gathering all the documents needed for the case, you believe that you have gained the knowledge and skills to assist Social Security Insurance (SSI) recipients when they have issues before the Social Security Administration (SSA), a federal agency. Based on your observations and familiarity with the administrative process, you know that the non-attorneys can represent individuals in SSI proceedings without being a licensed attorney. It's one of those expectations to unauthorized practice of law. It's one of those expectations to the unauthorized practice of law. You know you have to prepare the appropriate documents to appear before the agency and qualify to become a legally authorized representative in your own right. As a starting point, you go to the Social Security website and gather all the information you need to complete the process. As a starting point, you go to the Social Security website and gather all the information you need to complete the process. You also realize that there are mechanisms to get paid when you represent clients. There are forms that allow you to collect your fees directly from an award from the administrative court, but you are not sure of all the steps that need to be completed to be part of that program. Prior to setting up your business, you want to be sure you gain the proper approvals from the SSA to become a legally authorized representative. This is an exciting time as you believe you have the tools to make a difference and help those who need assistance with their SSI benefits. Administrative advocacy is an area where paralegals can gain opportunities to act as advocates for clients, similar to attorneys. Many of the federal agencies permit non-attorneys to represent individuals as this is one of those expectations. Many of the federal agencies permit non-attorneys to represent individuals as this is one of those exceptions to the unauthorized practice of law. This final chapter will explore informal and formal advocacy in the administrative process, both in the federal and state administrative agencies. Process may differ from agency to agency and state to state, so it is incumbent upon the paralegal to always stay abreast of the requirements to become a non-attorney advocate in the administrative agency in which the representation is sought. 15-1 Nature of Advocacy. Advocacy is the process by which an individual attempts to influence the goals or behavior of others. Advocacy is a basic component of everyday life. Note, for example, the advocacy involved or potentially involved in the following circumstances. At a supermarket checkout counter, a clerk tells a customer that the price of tomatoes is 99 cents a pound. The customer replies, but the sign back there said 89 cents a pound. The clerk says, I'm sorry, but the price is 99 cents. A student goes to the teacher to say that a term paper should have been graded A rather than B. A tenant tells the landlord that a $400 a month rent increase is ridiculous because the building has been steadily deteriorating. A homeowner has been away on vacation. Upon return, they find that their house has been burglarized. When they go to the police station to report the crime, they ask the desk sergeant why the neighborhood has not been receiving better protection in view of all the burglaries that have been occurring in the area lately. The sergeant replies that there are not enough police available to patrol the neighborhood adequately. The homeowner is not satisfied with this response and asks to see the precinct captain. The customer, student, tenant, and homeowners all have complaints. They are complainants. They are not satisfied with something. Their natural response is to make an argument for better service. In so doing, they become advocates for the objectives that they are seeking. Advocacy does not always require courtrooms, judges, and attorneys. All that is needed is a complaint, a person complaining, a complainant, and someone who may be able to act on the complaint. Formal advocacy occurs in court trials and in court-like hearings held by administrative agencies. As we saw in Chapter 7, an administrative agency acts like a court when it holds hearings presided over by a hearing officer or administrative law judge, ALJ. At such hearings, formal advocacy occurs through self-representation, attorney representation, and, where authorized, paralegal representation. Advocacy that takes place outside of court and court-like hearings is called informal advocacy. In the federal context, the guiding law for administrative advocacy is the Administrative Procedure Act, APA. This act sets forth the type of advocacy required in certain administrative settings. Generally, the APA provides for the instances when formal trial-like proceedings are required and are adversarial in nature. The individual or entity that is subject to a formal adjudication is entitled to a formal notice, which includes the nature of the hearing, The individual or entity that is subject to a formal adjudication is entitled to a formal notice, which includes the nature of hearing, with legal authority and facts that form the basis of the hearing, as well as the time and place of that hearing. These proceedings are before an administrative law judge on the record and are conducted similar to the trial proceedings we examined in Chapter 14. That means the parties present evidence, witnesses, exhibits, and prepare. That means that the parties present evidence, witnesses, exhibits, and prepare just like they would prepare for a formal civil or criminal trial. The administrative judge issues findings of fact and conclusions of law, resulting in a formal decision from the proceeding. These judges have virtually the same powers as federal and state court trial judges, in that they can issue subpoenas, make evidentiary rules, administer oaths for witnesses, conduct settlement conferences, or do anything that is authorized by their enabling statute, such as the APA. These judges are impartial, independent adjudicators for the agencies from which they are appointed. ALJs can generally only be removed for good cause, which is a protection afforded them which is a protection afforded them so that they can perform their jobs without fear of reprisal from the agencies they serve. On the other hand, when the APA does not provide a formal adjudication procedure, those actions by the agencies are considered informal adjudication, which is the way the majority of administrative disputes are handled. Although referred to as informal adjudication, some administrative processes do encompass some of the formalities of formal adjudication. Determinations of the type of proceeding that is due, a complainant is based upon the Fifth Amendment to the U.S. Constitution, of which so many of us are familiar with, that says no person shall be deprived of life, liberty, or property without due process of law. So when there is a deprivation of any of these rights, the individual is entitled to some form of due process, which is notice and opportunity to be heard. Where this differs for complainants is in the determination of what process they are actually due. This is dependent upon the right that the individual is being deprived of. Is it employment of a tenured professor? Is it employment of an untenured professor? Does the person have an actual entitlement to the property or service? Think of immigration claims, for example. What about veterans who seek benefits? What due process are they entitled to? These are questions that are asked to determine what type of due process is required. Ultimately, with informal adjudication, it is the agency's statutes and rules and regulations that guide the informal adjudication process. In some instances, such as the Department of Veteran Affairs, the administrative judge plays a different role. Here, they proactively develop the facts and claims of the case and are non-adversarial in nature. Juxtaposed to an immigration proceeding, there the judge is acting in a more formal trial-like setting. 15-1A, Judicial Review of Administrative Decisions. After an administrative law judge issues a decision, the losing party has a right to appeal that decision, usually to a court of law, such as the U.S. District Court. In that situation, the district court acts as an appellate-like court and has a narrow scope in which to review an administrative decision. There are 3 basic standards of review that a reviewing court applies to the agency decision. They are substantial evidence. They are 1, substantial evidence, 2, arbitrary and capricious, and 3, statutory interpretation. Substantial evidence standard. The substantial evidence standard is applied in formal adjudication proceedings. In this instance, the reviewing court looks at the entire record of the administrative agency. If an administrative decision is reasonable or the record's evidence is such as reasonable minds support that conclusion, the agency decision will stand. Arbitrary and capricious standard. The arbitrary and capricious standard is applied to informal adjudications. Under this standard, there must be a connection between the facts and decision made by the agency. Here, the question to be asked is whether the actions of the agency had a bias. Here, the question to be asked is whether the actions of the agency had a basis in law and fact, and whether Here, the question to be asked is whether the actions of the agency had a basis in law and fact, and whether the ALJ acted in an arbitrary and capricious manner. Essentially, did the ALJ abuse its discretion in rendering a decision? If the answer to the question is no, then the decision will stand. Statutory interpretation standard. Under this standard, a court performs a 2-step analysis based upon the landmark decision of Chevron USA Inc. versus Natural Resources Defense Counsel 467 U.S. 837, 1984. In that case, the U.S. Supreme Court held that when administrative actions are at issue, courts must look to whether Congress has spoken on the precise question at issue, ID at 843. If Congress has not directly addressed the precise question at issue, the court must determine if the agency actions was a permissible construction of the statute. ID at 843. Chevron promotes a differential standard to the agency's actions and gives them wide latitude in interpreting their own statutes and rules and regulation. Consequently, under this standard, the court asks itself whether the agency's interpretation of the statute or authority was reasonable. However, of late, this differential standard has come under challenge, leaving open the possibility of curbing the Chevron agency difference. However, of late, this differential standard has come under challenge, leaving open the possibility of curbing the Chevron agency difference. Whether Chevron remains intact is an open question. With these principles as a backdrop, let's take a closer look at informal and formal advocacy and where paralegals play a pivotal role in that process. 15-2, Informal Advocacy. Paralegals often have contact with organizations that require the use of informal advocacy techniques. An example is responding to resistance when trying to convince a caseworker or a social worker that the agency. An example is responding to resistance when trying to convince a caseworker or a social worker that the action an agency has taken or proposes to take is illegal or ill-advised. Exhibit 15-1 presents a summary of 21 techniques of informal advocacy that are sometimes used with varying levels of success when trying to obtain action from an administrative agency or from any large organization. Although some of the techniques overlap, they are listed in the approximate order of effectiveness. Of course, whether a particular technique will be effective depends on what you are trying to accomplish. Whether a particular technique will be effective depends on what you are trying to accomplish, whom the technique is directed against, and how well you execute the technique. In general, the techniques at the beginning of Exhibit 15-1 are more likely to be effective than those at the end. Exhibit 15-1. Techniques of informal advocacy. 1. Put your cards on the table. Be direct and completely above board in telling the agency official what your position is and what you want. 2. Insist on adequate service. Point out the agency official that the purpose of the agency is service and that this principle should guide the official's actions. 3. Ask to see the authority they are relying on. Insist that the agency official show you the regulation, law, or other authority that supports the action taken or proposed by the agency. 4. Climb the chain of command. Can I speak to a supervisor? Normally, everyone has a boss who can overrule decisions made by those beneath them. When you are dissatisfied with the decision or action of an employee, you can try to appeal or complain up the chain of command to the employee's supervisor and to the supervisor's supervisor as needed. 5. Insist on common sense. Convey to the agency official the impression that common sense supports your position, in addition to or despite regulations or technicalities that might be cited against you. 6. Take the role of the tired, battered, helpless citizen. Do not insist on anything. Play dumb, act exhausted, and act in such a way that the agency official will think the person needs help. Act as if everyone else has given you the runaround and you are praying that this official, whom you have not dealt with before, will finally give you a sympathetic ear and some help. 7. Cite a precedent. Point out the agency official if it is true that your case is not unusual because the agency has granted you. Cite a precedent. Point out the agency official if it is true that your case is not unusual because the agency has granted what you want to others under the same or similar circumstances in the past. 8. Find the points of compromise. Find the negotiable points in the dispute and determine whether you can bargain your way to a favorable result that gives you at least some of what you want. 9. Uncover the realm of discretion. Those in authority often want you to believe that their hands are tied, that there is only one way to apply the rule. In fact, some discretion is often involved in the application of rules. You need to find the realm of discretion and try to fit your case within it. The goal is to show that the discretion provides the agency official enough flexibility to give you what you are seeking. 10. Look for an opening by asking a very broad question. Pose a question to the official that is so broad that the answer may give you an opening. For example, has the agency ever granted XYZ before? Are you telling me that in the thousands of cases your agency has handled, you have never granted a request like mine? 11. Demonstrate the exception. Insist on the uniqueness of your client's situation. Show agency officials that the general rule they are using to deny your client a benefit is inapplicable. 12. Cite the law. Show the agency official that you know what administrative regulations apply to the case. Also cite statutes and other laws to demonstrate your point. Of course, if the law is clearly on your side, this technique, and number 13, would go at the top of the list. 13. Interpret the law. After citing a rule of law, explain to the official how the law applies to your situation. 14. Be a buddy. Show agency officials that you are not an enemy, that you respect and like them, and you are aware of how difficult their job is. 15. Make it clear that you are going to fight this case all the way up. Make the official aware of how important the case is. Point out that you are thinking about taking the case to a formal agency hearing, if available, and that your office may go to court if necessary. 16. Redefine the problem. If you can't solve a problem, redefine it, as long as you can still achieve the essentials of what you seek. For example, stop trying to qualify the client for Program A if Program B will serve the client equally well, or almost so. And if the problems of qualifying the client for B are not as great as those you face by continuing to assist on A. 17. Do a favor to get a favor. Be willing to do something within reason and the law for the person from whom you are seeking something. 18. Seek the support of third persons. Gather the support of individuals or groups within and outside the agency so you can demonstrate that you are not alone. 19. Preach. Lecture the agency official about their responsibilities within the agency. Elaborate on the mission of the agency, making clear that the denial of what you are seeking violates or is inconsistent with that mission. 20. Embarrass the official. Show the agency official that you do not respect them. Do it in such a way that the official is made to look silly. 21. Be angry. Show your hostility. Be completely open about the anger you feel concerning what is being done or proposed. Effective use of any informal technique of advocacy requires timing, evaluation, adaptation, and record keeping. A major threshold concern of an advocate is timing. Deciding when to intervene with the advocacy techniques. The decision to intervene involves a strategic judgment about when it would be most appropriate to seek what you are after at the agency or organization. For example, suppose that you must contact the complaint bureau of an agency that is relatively new to you. One approach would be simply to walk up to the complaint bureau and delve right into the matter that brought you there. Another approach would be to try to find out something about the bureau before going to it. Online information about the structure of the agency will provide you with at least a general idea of what to expect. You may be able to talk to attorneys or other paralegals who have had prior contact with the bureau. Suppose you learn that 2 agency employees rotate their work at the bureau and that one employee has a reputation of being more cooperative than the other. You may decide not to go to the bureau until this employee is on duty. In short, you decide to postpone your contact with the bureau until circumstances are most favorable to the objective you are seeking. As you use any of the techniques in Exhibit 15-1, you must simultaneously judge the effectiveness of the technique in light of what you are trying to accomplish. Are you making yourself clear? Are you complicating rather than resolving the problem? Are you getting through? Are you comfortable with the technique you are using? Are you pacing yourself properly? Is your insistence on immediate success encouraging a negative response that is counterproductive? One of the major signs of ineffective advocacy is becoming so involved in the case that you begin to take roadblocks and defeat personally. One of the major signs of ineffective advocacy is becoming so involved in the case that you begin to take roadblocks and defeat personally. Everyone agrees that objectivity is a good quality, and most of us claim to possess this quality in abundance. The unfortunate fact, however, is that we tend to lose objectivity as friction increases. The key is learning to manage situations with professionalism and acumen when faced with challenges. It is not how we manage the easy situations, it is how we manage the difficult situations and navigate a solution in seeming insurmountable odds. To coin a colloquial phrase, making lemonade from lemons. As a result, once you have disciplined yourself to identify the techniques you are using and to evaluate their effectiveness, you must be flexible enough to adapt your techniques and shift to more effective ones as needed. That's when you will shine as a true advocate, not only for yourself, but more importantly for others. 15-2A Sample Case. We now examine some of the informal advocacy techniques, Exhibit 15-1, in the context of the following fact situation. You are in your own home or apartment. You receive a letter from a local ISP, internet service provider, stating that your service will be shut off in 10 days if you do not pay your bill. Your spouse tells you that all the bills have already been paid. You call the ISP, which has an office downtown. When you question the clerk, the response to you is, "I'm sorry, our records reflect an unpaid bill of over 60 days. You must pay the bill immediately." To try to straighten matters out, you take a trip to the ISP office. In the dialogue that follows, the complainant is their own advocate. C is the complainant and E is one or more of the ISP company employees. As you read the dialogue, ask yourself how effective C's informal advocacy is. E, can I help you? C, yes, I want to see someone about a problem with my bill. E, I'm sorry, but the customer complaint division closed at 2 p.m. You have to come back or call tomorrow. C, closed. Well, let me see someone about terminating the internet service altogether. E, all right. Would you step over to that desk? Technique, if you can't solve a problem, redefine it as long as you can still achieve the essentials of what you are seeking. C, number 16 in Exhibit 15-1. The client is taking a risk. They cannot get to the complaint division, so they will try to achieve your objective through the termination division. They have substituted one problem, getting to the termination division, for another problem, getting to the complaint division, in the hope of expressing their grievance. Can I help you? Yes, I want to terminate my ISP service if I can't get this problem straightened out. You have to go over to the bill complaint division. C, look, stop sending me somewhere else. This has to be straightened out immediately. Technique, demonstrate anger. C, number 21. This is a dangerous tactic to employ. It is a fact of life, however, that some people respond to this kind of pressure. C, aren't you here to serve the public? Technique, insist on adequate service. Number 2, point out that the organization exists to serve and that you need better service. E, there are rules and procedures that we all must abide by. And C, your responsibility is to take care of the public. Technique, preach. Number 19, perhaps the most common way people try to change other people is to lecture them, to tell them what they should or should not be doing. Technique, embarrass the official. Number 20, make the official look silly and unworthy of respect. At this point, has the complainant lost objectivity? What risks are being taken? Do you think the complainant is aware of what they are doing? If you asked them whether they were being effective, what do you think their response would be? Is the complainant more involved with the justice of their case than with the effectiveness of their approach? C, I'd like to speak to your supervisor who is in charge to this office. E, well, Mr. Adams is the unit director. Their office is in room 307. C, fine. Technique, climb the chain of command. Number 4. Almost everyone has a boss who can overrule a subordinate's decision. If you're unhappy about a decision, complain up the chain of command to the top if necessary. E, can I help you? C, I want to speak to Mr. Adams about a complaint. Tell them that it is very important. E, just a moment. They go into Mr. Adams' office for a few moments and then returns. Just a moment. They go into Mr. Adams' office for a few moments and then returns. You can go in. C, Mr. Adams. E, yes, what can I do for you? I understand you are having a little problem. C, it's about this bill. I have been talking to person after person in this office without getting any response. I'm going in circles. I need to talk to someone who is not going to send me to someone else. Technique, take the role of the tired, battered, helpless citizen. C, number 6. E, well, let me see what I can do. I've asked the secretary to get your file. Here it is. The records say that you haven't paid several months' bills. Our policy here is to terminate utility service if payment is delinquent 60 days or more. C, what policy is that? Could I see a copy of this bill and what it's based on? Technique, ask to see the authority they are relying on. 3, make the agency show you the regulation, law, policy, or other authority that allegedly backs up the action it has taken or says it will take. What risk is the complainant taking by resorting to this technique? Is the complainant suggesting to Mr. Adams that they do not trust them? How would you have made this? How would you have made the request in this decision? How would you have made the request in this situation? Does the request always have to be made in a hostile manner? E. Well, I'll be glad to show you the brochure. C. I would like to see it and also the law it is based on. You are a regulated service, and my position, Mr. Adams, is that the bills have been paid. E. Well, our records don't reflect it. C. All the canceled checks used have not all come back from the bank yet. I would like a photocopy of your file on me. Under the law, I am entitled to it. Technique, cite the law. Number 12, demonstrate that you know what regulations and other laws apply to the case. E. You do have this right, but only if you make the request in writing. C. Let's be reasonable. I'm making the request in person. That should be sufficient. Technique, insist on common sense. 5. Show the agency official that your position makes good common sense, even if regulations or technicalities go against you. C. Surely your rule calling for a written request can apply when the person making the request is right in front of you. Technique, interpret the law. Number 13, regulations, statutes, and cases are often susceptible to more than one meaning. Identify and argue for the meaning most favorable to your cause. Technique, demonstrate the exception. Number 11, insist that your situation is unique and not governed by the general rule. C. Don't you have the power to waive this rule in such a case? Are you saying that the office never gives waivers? Technique, uncover the realm of discretion. Number 9, argue that rules do not exist until they are applied, and that in the application of the rules, officials often have some latitude in interpreting them in spite of their claim that their hands are tied by the rules. Technique, look for an opening by asking a very broad question. Number 10, pose a question to the official that is so broad that the answer may give you an opening. E, well, all right, I'll see if I can get a copy run off for you while you are here, but it will take a little time, and I must point out that it's highly irregular. C, now, Mr. Adams, I understand that you are a very busy person and that you have responsibilities more demanding than listening to people like me all day. Technique, be a buddy. Number 14, show the official that you are not the enemy, that you respect and like them, and that you are aware of how difficult their job is. Here, the complainant has obviously shifted tactics. They are no longer antagonistic. Consciously or unconsciously, the complainant has made an evaluation of how successful the techniques have been thus far and has decided on a different course of action. What risk is the complainant running in making this shift? What risk is the complainant running in making this shift? C. All I want is a 2-week extension of time so that I can collect the proof needed to show you that the bill has been paid. Technique, put your cards on the table. See number 1, tell the agency official directly and openly what your position is and what you want. E, well, we seldom give extensions. The situation must be extreme. I don't know. C. Mr. Adams, suppose we forget my request for a copy of the records for the time being. All I want is 2 weeks. Technique, find the points of compromise. Number 8, look for the negotiable points and figure out whether you can bargain your way to a good result. E. I don't think so. C. Well, Mr. Adams, it's either that or I'm going to go to court. All I'm asking for is some fair treatment. There's a principle involved, and I intend to fight for it. Technique: make clear that you are going to fight this case all the way up. C number 15. Make the official aware of how important this case is. When you have grounds to back you, point out that you are thinking about taking the case to court if necessary. E. I'm sorry you feel that way, but we have our rules here. It would be chaos if we broke them every time someone asked for it. C. Good day, Mr. Adams. Has the complainant failed? Were they a bad advocate? Has the complainant accomplished anything? Should they give up? Do you think they will? If they do not, do you think the complainant has learned, or that they should have learned, enough about the agency to come back next time better equipped to handle their problem? If they do not, do you think the complainant has learned, or that they should have learned enough about the agency to come back next time better equipped to handle their problem? If the complainant comes back, what approach should they take, and whom should they see? Should they see the supervisor of Mr. Adams? For example, these are some of the questions that should be posed to determine the effectiveness of the advocacy and what next steps that should be taken to accomplish the result that is desired. Social media and advocacy in government. The First Amendment to the U.S. Constitution protects freedom of speech, but how far does that protection extend, and under what circumstances may it be limited? During the pandemic of 2020, there were claims by administrative agencies such as the Centers for Disease Control and Prevention, CDC, and the Federal Bureau of Investigations, FBI, that information disseminated online was misleading and included contentious content. In turn, the Biden administration communicated directly to social media companies to curb misinformation posted. These communications resulted in a lawsuit filed by the states of Missouri and Louisiana, along with 5 social media users, entitled Missouri vs. Biden 2023, U.S. District Lexus 114585 2023, WL 5841935, WD July 4th, 2023, after the district court judge entered an injunction against the Biden administration. It was appealed. After the district court judge entered an injunction against the Biden administration, it was appealed to the Fifth Circuit Court of Appeals, where that court affirmed the injunction, although it modified its restrictions set by the district court. Missouri vs. Biden, 80F 4th 641 5th Circuit 2023. The U.S. District Court and the U.S. District Court and Fifth Circuit Court of Appeals enjoined the coordinated campaign by high-level federal officials from either coercing social media companies to engage in censorship or actively controlling those companies' decisions about the content posted on their platforms. ID at *7*15. However, the case at the U.S. Supreme Court involves government officials, both from the executive and administrative agencies. However, the case at the U.S. Supreme Court involves government officials, both from the executive and its administrative agencies, from communicating with social media site representatives, possibly impacting First Amendment communications. That case is Murphy v. Missouri. See generally Murphy v. Missouri, 601 U.S. 2023, where the court granted a stay from the lower court decisions. The case cited includes a dissent from 4 justices against granting the request for stay. At the heart of this case is the extent that allegedly incorrect or malicious information is being disseminated. At the heart of this case is the extent that allegedly incorrect or malicious information is being disseminated to the public about the pandemic, vaccines, and other issues. Thus, what it seems the court will decide is under what circumstances are communications persuasive and coercive, and when is the line crossed under the First Amendment. The point is that administrative agencies have needs in today's online age to communicate with social media platforms to often get their messages out. What this case seems to suggest is when social media information conflicts with facts, what communications are permissible under the First Amendment, and whose obligation is to correct the misinformation, if at all. Cases already have placed limitations on First Amendment speech, such as the line of pornography case from the U.S. Supreme Court, or when the speech incites lawlessness, as in the landmark case of Brandenburg v. Ohio, 395 U.S. 444, 89 SCT 1827-23 LED 2D 430-1969. For Murphy v. Missouri, those freedoms and limitations will be tested and ultimately be decided. However, know that social media is a powerful communication tool that reaches untold millions of users each day. The Murphy case will decide how far social media sites are permitted to go regarding the content they post. What obligations do social media sites have in checking the information posted, and what obligations do government officials have in assuring that information on social media is accurate? The U.S. Supreme Court will answer that question during its 2023 to 2024 session. For the answer, see analyze this below. Analyze this. What was the holding by the U.S. Supreme Court in Murphy v. Missouri, 2024? How was the First Amendment impacted in the case? 15-3 Procedural due process, where paralegals are authorized by law to engage in formal advocacy by representing clients at administrative hearings. See Chapter 4. It is one of the great challenges that they enjoy. In the remainder of the chapter, we will explore some of the skills required to perform this task effectively. After identifying the components of procedural due process, when the advocacy involves a government agency. When a government agency and a citizen have a serious dispute, basic fairness may require a number of procedural safeguards for the citizen. These safeguards are known as procedural due process. Let's look at an example. Sean is a civilian employee of the Army. One day they receive a call from the manager of the division, who says, "I have just finished reading the report of the assistant manager. Based on my own observations and on this report, it is clear to me that you have been using the office computer for personal purposes in violation of agency policy. I have decided to terminate your employment. As a matter of fairness and common sense, what is wrong with the manager's approach? Assume that Sean denies the charge and that this is the first time they have heard anything about an alleged improper use of an agency computer. The resolution of a legal dispute requires the application of substantive and procedural law. Substantive laws are the non-procedural laws that define or govern rights and duties, like, for example, the duty to use reasonable care to avoid injuring someone. In our example, the substantive law question is whether Sean violated any laws in using the computer. Procedural laws are the laws that govern the mechanics of resolving a dispute in court or in an administrative agency, like, for example, a rule on the time by which a party must respond to a complaint. In our example, the procedural law question is whether the agency's method of resolving the dispute with Sean is fair. The latter is a question of procedural due process. In Exhibit 15-2, you will find some of the visceral responses that Sean or any citizen might make, plus their legal translation in terms of procedural safeguards. Exhibit 15-2. Procedural safeguards, procedural due process. Facts. Sean was fired on the day he was told he was suspected of improper computer use. Note, the following overview of procedural rights covers challenges against something the government has done. Here, firing a government employee. The following overview of procedural rights covers challenges against something the government has done. Here, firing an employee. The overview does not cover procedural rights persons may have. The overview does not cover procedural rights persons may have when the dispute is between private or persons of. The overview does not cover procedural rights persons may have when the dispute is between private persons or entities. Visceral response to treatment of Tom by the agency. Before I was fired, I should have been told that the agency thinks I used the computer illegally. Show me the report that the assistant manager wrote on me so that I can see what he's talking about, and tell me what made you, the manager, arrive at your conclusion about what I did. Before you fire me, give me a chance to come before you to explain myself. Note, however, that a citizen is not entitled to all the components of procedural due process outlined in Exhibit 15-2 in every dispute with a government agency, as we have already discussed. What procedural safeguards are required? The answer depends primarily on the seriousness of the dispute. In a hearing on terminating public assistance, for example, all 10 safeguards listed in Exhibit 15-2 are required when the recipient is challenging the termination, which may be considered a property right. Because of this property right, someone whose public assistance is being threatened has more procedural safeguards under the law in these hearings when an ALJ has to determine whether those consequences should be imposed. Analyze this. Determine what type of procedural due process is required in the following situations. 1. Termination of a license to be a taxi cab driver or limousine driver. 2. Termination of employment as a tenured professor. 3. Termination of veterans' benefits. One of the more important cases on procedural due process is Matthew versus Eldridge. One of the more important cases on procedural due process is Matthews versus Eldridge, 424 U.S. 319, 1976. This case set forth a 3-pronged test to apply when determining the type of due process that is required for an individual, thus asking the question, what process is due a complainant? This case set forth a 3-pronged test to apply when determining the type of due process that is required for an individual, thus asking the question, what process is due a complainant? Order of the court, a case study. Matthews versus Eldridge, United States Supreme Court, 424 U.S. 319, 1976. In Matthew versus Eldridge, a welfare recipient's Social Security disability benefits were set to be terminated. The question before the U.S. Supreme Court was whether the government had to provide a pre-termination hearing to a recipient prior to discontinuing the disability benefits. George Eldridge had been receiving disability benefits from 1968 due to a back strain and chronic anxiety. In 1972, he received a letter from a state agency that monitored his condition that stated his benefits would cease. That notice was sent to SSA, who accepted the state agency's findings and thus informed Eldridge that his benefits were going to be stopped since his disability has ceased. After receiving the notice, Eldridge filed an appeal arguing that he had a right to a hearing prior to the termination of his disability benefits. Not granting a hearing violated his due process rights. Basing his decision on prior U.S. Supreme Court precedents, he argued that Goldberg v. Kelly applied, where in that case a hearing was basing his decision on prior U.S. Supreme Court precedent. He argued that Goldberg v. Kelly applied, where in that case a hearing was required prior to terminating welfare benefits. He required his termination of disability benefits required the same procedural due process. He argued his termination of disability benefits required the same procedural due process. The lower courts agreed with Eldridge, but the SSA appealed to the U.S. Supreme Court. The court reversed the lower court's decisions and found against Eldridge. The court reversed the lower court's decisions and found against Eldridge. In their opinion, they set forth the three-pronged test that is still used today. It considers 1, the private interest that will be affected by the official action. 2, the risk of an erroneous deprivation of such interest through the procedures used and probable values, if any, of additional procedural safeguards. And 3, the government's interest, including the fiscal and administrative burdens that the additional or substitute procedures would entail. ID at 335. The court distinguished medical and financial information and considered those involving medical benefits of less value than those for welfare benefits. More importantly, the court found that the administrative burden on the system would be too great without establishing the necessary benefits for such a hearing requirement. In concluding, the court opined that terminating disability benefits does not impact families in the same way as welfare benefits, and observed that, if necessary, families could then apply for welfare benefits. Discussion questions. Review. Matthews v. Eldridge. Was the court's reasoning sound? Should welfare and disability benefits have different levels of due process protections? Were there concurring and dissenting opinions? If so, who wrote those opinions? 15-4 Formal Advocacy. What would it be like to stand before a judge? And what would it be like to stand before a judge and it would be you, yes, you, standing without a law degree before a judge representing a client? A person in need would be depending on your ability as a representative to help win the case. What would it be like? Jeffrey S. Wolf, U.S. Administrative Law Judge. Judge Wolf is referring to the right that non-attorneys have to represent their own clients before designated administrative agencies. In particular, he is referring to his own agency, the Social Security Administration, SSA, where you do not have to be an attorney to represent clients. As we saw in Chapter 4, there are a number of state and federal administrative agencies that allow paralegals to provide a full range of legal services, including representation of their own clients at administrative hearings. One of the largest agencies where this occurs is the SSA. Although formal administrative advocacy differs from agency to agency, An examination of a paralegal's role at the SSA can help us understand what is possible at many agencies. One of the SSA's largest programs provides disability benefits to individuals who suffer from an inability to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment. Every year, millions of people apply for Social Security disability benefits under one of two programs: disability insurance benefits, DIB, for individuals who have a qualifying work history; supplemental security income, SSI, for individuals who may have never worked. Nearly 2 million of these applications are denied. The denials lead to a staggering number of annual appeals handled by federal administrative law judges, ALJs, like Judge Wolf, throughout the country. The Social Security Administration adjudicates more cases than all federal courts combined. Social Security law, as many citizens know from first-hand experience, can be complicated. This is particularly true of disability law. Consequently, the need for legal assistance in the annual disability hearings is enormous. Unfortunately, not enough attorneys practice Social Security law, although a growing number take Social Security cases under the broader practice of elder law. Elder law is an area of the law that specializes in areas that affect the older adult population. Part of the reason many attorneys stay away from disability cases is that they do not generate enough revenue for the attorneys. In most cases, a representative can collect now $7,200 or 25% of back due disability benefit. In most cases, a representative can collect now $7,200 or 25% of back due disability benefits, whichever is less. The fee cannot be higher, even if the client agrees to pay more. This maximum fee fluctuates and is adjusted from time to time. However, this is not enough to interest many attorneys. Fortunately, claimants seeking legal representation have an alternative. Congress has specifically provided that people other than attorneys may represent claimants before the Commissioner of Social Security. Hence, paralegals have a federal mandate to practice law before the SSA, including the right to charge fees for their services. To be a representative, the paralegal must know the significant issues in a claim and have a working knowledge of Social Security statutes, regulations, and rulings. One of the ALJs makes the following comment about the effectiveness of paralegal advocates in Social Security cases: "It's not being a lawyer that makes a difference, but knowing what is a disability. Non-attorney advocates who know what they are doing do a better job than an attorney who doesn't know disability." Social Security representatives have formed the National Organization of Social Security Claimants. Representatives, NOSSCR, consisting of attorneys and other advocates, www.nosscr.org. Attorneys and paralegals have the same responsibilities and representatives in SSA hearings, but they are treated differently in the crucial area of fees. When attorneys win a disability case, their fee is deducted from the claimant's award by SSA and sent directly to the attorneys. When non-attorney representatives win a case, however, they must collect their fee on their own from the client unless they pass an exam on Social Security law, obtain liability insurance, and take designated continuing legal education CLE sessions. The first step in being a representative is to be appointed by the client. See Chapter 4 for the form that a Social Security applicant must use to appoint a representative. Now let's examine the facts in the introduction of and the introduction of the paralegal who wants to start a business. To assure success in the business of representing SSI recipients, our paralegal should review what is required to become eligible as a non-attorney representative. By reviewing the online application, it appears that complying with the educational requirements is a critical component of the process. To meet the minimum educational requirements, a non-attorney must have either a bachelor's degree or high school diploma with at least 4 years of experience. That the commissioner determines to be equivalent to a bachelor's degree. Our paralegal appears to have the minimum qualifications as they have 5 years of experience in the field. We do not know if the paralegal has a bachelor's degree, as that would make it easier to qualify. Additionally, our paralegal must pass an examination in order to qualify as a legal representative. These requirements are not insurmountable, but a hurdle that must be overcome to meet the requirements to start the new business. These are some of the first steps that our paralegal from our chapter introduction must employ to gain certification as a non-attorney representative. Online exercise. Go to www.ssa.gov and find the application form for non-attorney representative. Identify all the requirements to meet the eligibility qualifications. Quick tip. There is an advantage to being an eligible non-attorney representative for SSI recipients as non-attorney representatives who do not meet these eligibility qualifications. There is an advantage to being an eligible non-attorney representative for SSI recipients as non-attorney representatives who do not meet these eligibility qualifications must collect their fees directly from their clients. That is more difficult than the collecting directly from the agency from the reward. 15-4A Sample Case. To gain a greater appreciation of paralegal representation at SSA disability hearings, we will examine a sample case involving a dispute on an overpayment to a recipient of disability payments under the Supplemental Security Income SSI program. Here are the major participants in the case. Mary O'Brien, SSI recipient and claimant. George O'Brien, Mary's husband. John Powell, paralegal representative of Mary. Helen Davis, witness for Mary. Alex Bolton, administrative law judge at SSA. (15-4B) Background. Mary O'Brien is disabled. She suffers from depression, an affective disorder, and receives $531 a month in SSI. When Mary applied for SSI benefits, she told SSA that her husband, George O'Brien, earns $3,600 a year from a part-time job as a night watchman, and that this amount was the total O'Brien income. The $531 a month awarded to Mary was based on this annual figure. Mary and George have a strained relationship, although they continue to live together. She is not aware of what he does during the day. Indeed, when she questions him about his activities, he becomes hostile. He can be violent. On June 1st, 2020, she called the police when he went into a rage. The police referred Mary to the County Domestic Violence Center. She went there and met with a counselor, Helen Davis. After describing what happened, Davis advised Mary to obtain a restraining order against her husband. Mary, however, did not want to involve the courts. She felt this would enrage her husband all the more. Hence, she did not file for a restraining order, although she continued to come to the center to attend counseling sessions for abused women. On September 1st, 2021, SSA sends Mary a notice of overpayment. It states that according to information received from the Internal Revenue Service, George O'Brien reported taxable earnings of $12,000 during the year 2020. The payment of $531 a month was based on a household income of $3,600. Since George was in fact earning considerably more, the 2020 entitlement has been recalculated. The SSA has concluded that Mary received an overpayment of $3,250 during 2020. To recoup this amount, SSA will deduct $53.10 a month from her disability check until the overpayment of $3,250 has been repaid. This notice is quite distressing for Mary. Mary calls the local neighborhood legal aid office for help. On the phone, a receptionist determines that she is eligible for free legal services because of her low income. The receptionist tells Mary to come in the next day for an appointment with John Powell, a paralegal in the office who handles Social Security cases. John conducts an extensive interview of Mary, who tells John that George admits to earning the extra money in 2020, but that it was none of her business. He works as a night guard for a security firm that is managed by his cousin. She also describes his anger and violence over anything that questions or challenges his authority, or that he considers an interference in his affairs. 15-4C, Pre-Hearing Advocacy. John points out to Mary that if the extra money was earned, the only way to avoid making the repayment is to file a request for waiver of overpayment. www.ssa.gov or perform a general Google search on the ground that Mary is without fault in causing the overpayment or in failing to report it, and that requiring repayment will be a hardship and is against equity and good conscience. Furthermore, if they act quickly, they might prevent SSA from starting the deductions from the monthly disability check. Mary begins to feel relieved and signs the SSA form appointing John as her representative and asks him to take whatever steps are necessary to try to avoid the repayment. He explains that if the request for waiver is denied, they can ask for a conference to explain their side, and ultimately they can ask for a rehearing before an administrative law judge, ALJ. In the weeks following the meeting between John and his client, a number of events occur. John helps Mary fill out the request for waiver of overpayment. The basis of the request is that Mary is without fault because she knew nothing about her husband's side job. He is secretive about his finances, and he is abusive, particularly when she questions him about anything he does outside the home. John sends this request to SSA, along with a cover letter asking SSA not to begin deductions from Mary's monthly payment until the appeal process is completed. John makes this request as a precaution, even though SSA's policy is not to begin adjustment action until the waiver issue is resolved. A month later, SSA sends Mary and John its response. The request for waiver is denied. John then asks the SSA field office for a personal conference, during which he and Mary will explain their case before an SSA official who has not been involved in the initial decision to require the repayment of the overpayment. This request is granted. 5 days before the personal conference, John exercises Mary's right to go to the SSA office in order to examine the file that contains the records used by the SSA to demand the return of the overpayment. He photocopies the records that he does not already have. But studying the SSA records in Mary's file, John identifies further evidence he needs to check in order to be better prepared to respond to the SSA's case against Mary. The personal conference takes place at the SSA office. It lasts about an hour. John goes over the details of what happened during 2020 and why Mary knew nothing about what it lasts about an hour. John goes over the details of what happened during 2020 and why Mary knew nothing about George's extra income. One of the reasons the conference is valuable, even if it does not result in a decision in Mary's favor, is that it gives John a clear understanding of the SSA's case against her. A month later, Mary and John receive a notice from the SSA reaffirming the decision not to grant her the waiver. Further efforts to resolve the case, including use of reconsideration procedures, are unsuccessful. Reconsideration procedures is a mechanism a claimant can use to challenge an initial determination by the SSA. It must be in writing to the agency and states the basis for the reconsideration with any additional supporting information. As noted, this procedure was utilized, which means that John then files a request for hearing before an ALJ, www.ssa.gov. Several weeks later, John receives a call from the Office of Hearings and Appeals to arrange a date for the hearing. After John consults with Mary, a date for the hearing is set. John and Mary receive a formal notice of hearing indicating that the hearing will be held before U.S. Administrative Law Judge Alex Bolton on the agreed upon date. 15-4D Characteristics of Disability Hearings. A disability hearing in SSA's Office of Hearings and Appeals is non-adversarial because it is a one-party proceeding. An official representing the SSA is not present. The only party at the hearing is the claimant, along with the ALJ. At a hearing, the following participants might be present: claimant, representative of claimant, here a paralegal, witnesses, like for example a vocational counselor or a relative, reporter, often an SSA secretary who makes a voice recording of the hearing, presiding ALJ. See Exhibit 15-3 for a typical arrangement of an SSA hearing room. Exhibit 15-3, typical Social Security hearing room. An administrative law judge, ALJ, presides over a Social Security hearing. Present are the paralegal representative, the claimant, witness, and a court reporter. Before the paralegal begins asking questions of the witness, the judge swears in the witness. The absence of an SSA representative, however, does not mean that the claimant's representative will have an easy time establishing the position of the claimant. The ALJ is not an advocate, but has an obligation to develop the record. To fulfill this duty, the ALJ might take an affirmative role at the hearing, such as by actively questioning the claimant, and, if needed, arranging for a vocational expert to be present to give testimony. The representative must convince the ALJ that the claimant's case fits within the guidelines of eligibility for a waiver of the overpayment. This is done primarily through the testimony of the claimant and other witnesses, and the introduction of documentary evidence such as medical and vocational records. Medical records can be lengthy, complicated, incomplete, confusing, and at times contradictory. Nevertheless, most ALJs will not tolerate a sloppy presentation. They will hold a representative's feet to the fire by insisting on a coherent presentation of the claimant's case. The representative must be able to anticipate possible questions from the ALJ and provide answers by citing information on specific pages of exhibits in the record. Competent representation can be a challenge, even though the other side, the SSA, is technically absent and unrepresented. A disability hearing is similar to a court trial in that both are on the record proceedings in which testimony is given under oath. A reporter is present at the disability hearing to tape record everything that is said. Yet, unlike court trials, the rules of evidence do not fully apply to disability hearings. Their application is more relaxed because oftentimes unrepresented individuals appear before the ALJ. As a result, the ALJ will consider any evidence that is relevant, broadly defined to the issues in the case. Judges in court trials are not as liberal on what is allowed in. To a large extent, the conduct of a hearing depends on the style and personality of the presiding ALJ. Some ALJs will let the representative take the lead by making an opening statement, introducing documentary evidence, and questioning witnesses. The ALJ might ask questions after the representative has finished. Other ALJs take a more aggressive role. They might not allow the representative to take over until they ask their own questions of the claimant or other witnesses. 15-4E. Preparation for the hearing. To prepare for Mary's hearing, John does the following. Asks Helen Davis to come to the hearing as a witness for Mary. Davis is the counselor at the County Domestic Violence Center, where Mary went for assistance during 2020. In the event Davis cannot come to the hearing, John will obtain an affidavit which will state the circumstances of Mary's involvement with the center. The reason that this is a useful alternative is because an affidavit is sworn to, and it generally has an assertion that the person attests to the truthfulness of the contents of the affidavit. Although the ALJ cannot question someone when an affidavit is submitted, which is a drawback, it is evidence of the facts that support or in the alternative do not support a person's position. Analyze this. List other types of legal proceedings where an affidavit may be used and why. Think of the litigation context. Obtains a letter from Mary's doctor, David Steps, MD, that describes the medication he prescribed for her due to the tension she was under at home. Researchers this medication online and finds a report from the National Institute of Mental Health, NIMH, on the reasons the medication is prescribed and its side effects of lethargy and extreme sensitivity to conflict. John downloads this report and prints the pertinent section for the use at the hearing. researches battered women syndrome online and finds a medical study on the helplessness experienced by women faced with severe abuse from their spouses and significant others. John downloads and prints the study for use at the hearing. Researches SSA's policy manual, Program Operations Manual System, POMS, online to make sure he has a full grasp of all of the procedures that SSA should be following in Mary's case. Prepares a complete summary of all Mary's assets and liabilities, showing monthly household income and expenses. Obtains copies of the O'Brien's federal and state tax returns for 2020. Compiles Mary's medical history, which will be relevant to the hardship issue, particularly the amounts paid for drugs and other medical care, and to her ability to handle stress and understand household finances. Prepares a set of notes in which John identifies Mary's theory of the case, together with citations to applicable regulations and supporting facts in the exhibits. Meets with Mary in the office to go over what is likely to happen at the hearing and to role play Mary's responses to the questions that he plans to ask her and that the ALJ might ask her. John comments on each of her responses, pointing out the importance of telling the truth and of giving detailed answers. John tells Mary that the hearing will be tape recorded and to speak clearly and answer questions verbally. The tape recorder will not know if Mary answers a question with a nod of her head. Quick tip: preparation, preparation, preparation. To have a higher degree of success at a hearing before an ALJ, it is important to be organized and prepared in your presentation and questioning of a client or witness. Write down the questions that are intended to be posed so all the required information is covered and nothing is left to chance. 15-4F, the O'Brien hearing. Judge Bolton begins the hearing by introducing himself and letting everyone know that a reporter will be recording the proceeding. He asks everyone to identify themselves for the record. Mary O'Brien, SSI recipient and claimant. John Powell, paralegal representative of Mary. Helen Davis, witness for Mary. Judge Bolton then turns his attention to the reports and other exhibits already in the file and those that anyone wants considered. They are all identified with an exhibit number. The judge asks John if they have any objections to any of the exhibits. John responds that they do not, but hopes to have the chance during the hearing to comment on some of the SSA reports in the file. Quick tip: just like you would prepare for a hearing or trial in a formal setting, having all exhibits numbered and identified is an important component of your preparation and professionalism. Keep a log of the exhibits that are used as evidence in the hearing. Judge Bolton administers the oath to tell the truth to all witnesses who will be giving testimony, Mary O'Brien and Helen Davis, and tells John to present their case. John begins by summarizing the position of the client, that Mary is without fault in receiving the overpayment because she had no knowledge of the extra earnings of George, and that George has been physically abusive to Mary whenever she has tried to question him about any financial matters. John also says that forcing a repayment would be a severe hardship on Mary. John then asks Mary a series of questions to elaborate on these and other relevant points. For example, who takes care of the finances in the household? Is your name on any bank accounts with George? Describe the living expenses you and George have in the home. Explain whether it will be a hardship to have to repay the overpayment. Has George told you what he does during the day? When do you see George during the course of a typical day? Did George hit you during 2020? Did you call the police? Why were you referred to the County Domestic Violence Center? Did you meet with Helen Davis, a counselor there? What did Helen advise you to do? Did you ever consider obtaining a restraining order? If so, describe what happened. Why have you continued living with George, who is abusive? Are any other living arrangements available to you if you leave George? Describe your health during 2020. Were you taking any medication? What effect did the medication have on you? While asking such questions, John refers to specific exhibits such as the letter of Dr. David Steps on why certain medications were prescribed, the report on the other While asking such questions, John refers to specific exhibits such as the letter of David. While asking such questions, John refers to specific exhibits such as the letter of Dr. David Steps on why certain medications were prescribed, the report on the side effects of the medication, and the study on the battered women syndrome. When John finishes questioning Mary, Judge Bolton asks Mary several questions about her educational background and about the times at home when she was able to get along with George. After Mary answers, John asks some follow-up questions designed to reinforce her inability to understand financial matters and her fear of George. Finally, John questions Helen Davis, the counselor at the County Domestic Violence Center. John asks Helen to explain the services of the center and the level of agitation and fear Mary expressed when coming there for help. John asks Helen whether it is common for abused women to remain with their abusers. Finally, John asks Helen to explain why she recommended that Mary obtain a restraining order against George and whether it is unusual for an abused woman to be afraid to do so. At the conclusion of all the testimony, John Bolton thanks everyone and says that he will render a decision as soon as possible. At the conclusion of all the testimony, Judge Bolton thanks everyone and says that he will render a decision as soon as possible. Before leaving, John has one final request of Judge Bolton. John asks if they can submit a memorandum to the judge in which they present the facts in light of the applicable law. Judge Bolton says he will be glad to receive such a memorandum. John knows that ALJs hold many hearings, and a memorandum of this kind might help influence the outcome of the case. Preparing it after the hearing gives John the opportunity to highlight those facts and legal matters that appear to be of concern to the ALJ at the hearing. 7 months after submitting the memorandum, John and Mary received the decision of John Bolton. 7 months after submitting the memorandum, John and Mary received the decision of Judge Bolton. Mary is found to have been without fault in causing the overpayment, and it would be an undue hardship to require payment. Mary is found to have been without fault in causing the overpayment, and would be an undue hardship. Mary is found to have been without fault in causing the overpayment, and it would be an undue hardship to require repayment. Victory. Quick tip. Offering to prepare a memorandum to the ALJ is an excellent tactic to set forth the facts and law of your case, essentially unopposed since this is a non-adversarial proceeding. If you are a non-attorney advocate in an administrative setting, requesting to submit a memorandum in support of your case should become a standard part of your representation of a client. (15-4G) Further appeals. If the decision had gone against Mary, the next step would have been a request for review by the Appeals Council. This is an appeal within the SSA. The claimant submits a brief to the Appeals Council indicating why the decision of the ALJ should be reversed. John would prepare the brief for Mary. A paralegal representative can write and sign these briefs. In the vast majority of cases, neither the party nor the representative makes a personal appearance before the Appeals Council. If a claimant were dissatisfied by the decision of the Appeals Council, the next step would be an appeal to a U.S. District Court. The case could be taken to court because the party had exhausted administrative remedies. That means that the party has taken advantage of all possible administrative proceedings before filing a case with the U.S. District Court. At this point, an attorney would have to take over the case, although a paralegal could assist the attorney as in any court case. The attorney could ask a paralegal to help prepare the pleadings and briefs that would be submitted to the court, but only an attorney could sign them. The federal authorization for paralegals to represent claimants within SSA does not include court representation. Quick tip: although authorized by the Social Security Administration or even another permitted administrative agency, non-attorneys cannot represent others before a district court, as that would be the unauthorized practice of law. Analyze this. Why is it not the unauthorized practice of law for a non-attorney to represent individuals before the Social Security Administration? Do these same principles apply to non-attorneys representing individuals before the Equal Opportunity? Do these same principles apply to non-attorneys representing individuals before the Equal Employment Opportunities Commission, EEOC, the Immigration and Naturalization Service, INS hearings? Explain your response. The appeals process does not end in the U.S. District Court. A district court will review the decision of the administrative agency. Its review is limited to the record from the administrative agency. As a result, agency decisions are given great deference and are not as easily overturned as other court decisions. If a party does not agree with the decision of the district court judge, that party can appeal to one of the federal courts of appeal. Here, the matter will be heard before a group of 3 panel judges who will decide the issue based on the record from the lower court and administrative agency. The briefs of the parties and oral arguments if permitted. The appeals court will render a decision which can be appealed to the U.S. Supreme Court, as we will see in our case study below. 15-4H Conclusion. As you can see from John Powell's role as a representative before the SSA, formal administrative advocacy by paralegals where allowed can be a major undertaking, although most paralegals do not have the opportunity to engage in such advocacy in their everyday work. You might consider pro bono work where such advocacy is needed. There are neighborhood legal aid societies, senior citizen groups, and homeless projects in many cities that would become part-time volunteer work on Social Security cases. Perhaps you could inquire about teaming with an experienced paralegal whom you could assist until you felt comfortable enough to venture out on your own cases. The need for legal help in this area is enormous. For a SSI case that went all the way to the U.S. Supreme Court, we review United States v. Velo Madero, 596 U.S. 142 SCT 1539 212 LED 2D 496 2022, In this case, Mr. Velo Madero was receiving his SSI benefits while living in New York, but when he moved home to Puerto Rico, the payments ceased. Order of the Court, a case study, United States versus Velo Madero. United States Supreme Court, 596 U.S. 142 SCT 1539212 LED 2D 496 2022. United States versus Velo Madero involves a claim for Supplemental Security Income SSI benefits by Jose Luis Velo Madero. Mr. Velo Madero lived in New York but moved back home to Puerto Rico in 2013. He did not notify the Social Security Administration SSA of his move and continued to receive benefits which amounted to overpayments of more than $28,000. Puerto Rican residents do not qualify for SSI benefits because of their status as a territory. The SSA sued Velo Madero for the overpayments. Velo Madero responded by invoking the Equal Protection Clause of the Fifth Amendment's Due Process Clause. All the lower courts found in favor of Velo Madero. The U.S. Supreme Court did not and reversed all the lower courts' decisions. Here, the court stated that Velo Madero was not entitled to the benefits because Congress had excluded Puerto Rico from SSI benefits. The court focused on two of its precedents, Califano v. Torres and Harris v. Rosario. Califano held that Congress could decide not to extend SSI to Puerto Rico under the constitutional right to interstate travel. Similarly, in Harris, the court again found that not extending federal benefits to Puerto Rico did not violate the U.S. Constitution's Fifth Amendment Due Process Clause. That court held that so long as Congress had a rational basis for not extending benefits to Puerto Rico, that was a permissible act under the U.S. Constitution. With these two cases as a framework, the court focused not on the fact that Velo Madero had been receiving benefits while in New York, but rather on Puerto Rico's tax status. The court reasoned that since Puerto Rico as a territory is exempted from many federal taxes, there was a rational basis for distinguishing it from the other states. The court further reasoned that if the SSI benefits were extended, Puerto Rico arguably would have to now pay the federal taxes in which it had been exempted, burdening the Puerto Rican economy as well as those of the other territories that were exempted from SSI benefits. The end result was that denying Puerto Rico SSI benefits was a proper exercise of Congress's authority. How and when Congress decided to structure tax and benefits for residents of the territories was plainly within its purview, and thus the denial of SSI benefits to Velo Madero was not unconstitutional or a violation of his rights. Discussion questions. Examine United States versus Velo Madero. Examine United States versus Velo Madero. What facts would have changed the court's result? Were there concurring and dissenting opinions in the case? If so, who were the authors of those opinions? Why was the status of Puerto Rico as a territory a critical fact in United States versus Velo Madero? 15-5 State Administrative Proceedings, Informal and Formal Advocacy. Like the federal government, states Like the federal government, states have informal and formal administrative advocacy. State administrative procedures and proceedings vary greatly. Therefore, state procedures should be consulted by reviewing statutes or administrative rules and regulations when participating in an administrative hearing, informal or formal. Some states permit non-attorneys to represent individuals at some agencies, but that is dependent upon the agency and the state involved. Checking the state agency websites or going in person, where you require assistance or guidance in using their administrative process, is helpful and, in some cases, mandatory. Many state agencies have YouTube videos to assist with the process. Depending on the process, witnesses and evidence may be presented as well as the filing of motions and other information that will support the case. States like California, Michigan, Texas, and New York have extensive administrative procedures and assistance where handbooks are available to guide individuals through their processes and what to expect. What is important at the state level is to recognize that state processes are not uniform. Researching your state's administrative procedures is critical to have a successful result in a client's case. Online exercise. Determine the procedure for your state's administrative process for challenging the suspension of a driver's license. Does your state permit a trial-like procedure, or is it non-adversarial? Detail your response with the process in your state. 15-6 Litigation Support. The role of the paralegal in the administrative process. The paralegal has a different role in the administrative process depending on the agency and the jurisdiction. In some state jurisdictions and in the federal system, paralegals can represent individuals in cases before agencies, as we have seen in the O'Brien hearing and our introductory facts at the beginning of the chapter. This also was discussed in Chapter 4. It is incumbent upon the paralegal to research the parameters of client representation in the administrative setting in which they are going to engage. This includes a registration requirement with the agency as well. However, in addition to possible representation of an individual, the paralegal will engage in other essential tasks in the administrative process. They may 1. Interview the client and assist in the investigation of a claim. 2. Prepare, organize, and create the file for the case. 3. Interview witnesses and take witness statements, including follow-up of the witness. 4. Draft and prepare documents for the case, including the initial filing and correspondence. 5. Request documents such as employment and medical records. 6. Organize and assist in the management of the case. 7. Prepare a hearing notebook similar to a trial notebook. 8. Assist the supervising attorney at the hearing by taking notes, managing exhibits and witnesses, and performing any other required tasks. 9. If permitted, represent the client in an administrative hearing. Remember that licensure or registration with the agency may be required. 10. Assist in any post-hearing tasks, such as preparing the appeal, gathering the record, and writing any required memorandum. Assist in any post-hearing tasks, such as preparing the appeal, gathering the record, and writing any required memorandum. Note that if a matter is appealed to a court, that must be handled by a licensed attorney. These are just some of the tasks a paralegal may perform in the administrative process, whether informal or formal. For a diagram of the administrative process, see Exhibit 15-4. Exhibit 15-4, Diagram of Administrative Process. An administrative action is filed by an individual because an agency action begins the administrative process. An informal hearing occurs between the parties and the agency. Evidence and testimony submitted. Mid-level agency, official, mid-level agency, official, Mid-level agency, official, AHO, makes proposed findings of fact and conclusions of law. Agency commission makes a decision on challenged matter. Losing party can file an appeal in accordance with statute or agency rules and regulations. Decision is rendered, and individual can appeal that decision to a court of law. Appeal filed in court of law, challenging decision of administrative agency. Court reviews agency action and issues a decision. If result is unsatisfactory, an appeal can be filed to an appellate court, who will review and render a final decision. (15-7) Rulemaking authority of administrative agencies. Not only does the Administrative Procedure Act, APA, and state statutes provide for formal and informal advocacy procedures, these statutes provide for the authority to make rules and regulations that govern conduct and behavior of individuals and businesses. In the APA, for example, it provides that federal agencies must develop rules and regulations and provide an opportunity for notice and comment on those prospective rules and regulations. Federal rules and regulations must be published in the Federal Register for a specified period of time. Federal rules and regulations must be published in the Federal Register for a specified period of time. Oftentimes, rules and regulations are amended, clarified, or even changed before they become final based on the comments provided by the public. Those that provide comments include individuals as well as advocacy groups and others who may have a particular interest in the rules that are being promulgated by the agency. Think about agencies such as the Environmental Protection Agency, EPA. Think about agencies such as the Environmental Protection Agency, EPA, the Social Security Administration, SSA, or even the Federal Communications Commission, FCC, who issue rules and regulations that have a direct impact on individuals and businesses. Citizens want to comment and have input on rules and regulations that may have a direct effect on them. That is why the notice and comment period for proposed rules and regulations is so important. By commenting on the proposed rule or regulation, you also are being an informal advocate. Think of those fundamentals at the beginning of the chapter in the informal advocacy process. In the federal administrative process, there are two kinds of rulemaking, formal and informal. Each is an important component in the administrative process. Formal rulemaking is usually dictated by statutes such as the EPA. Formal rulemaking is usually dictated by statutes such as the APA and requires trial-like proceedings when making rules and regulations for an agency. Under this process, formal comments are made in the trial-like setting and heard before agency officials are based on evidence in the record. Under formal rulemaking, evidence and witnesses are presented, including cross-examination. Just like a trial, rebuttal evidence is permitted as well. This process is not as commonly used as informal rulemaking. Informal rulemaking requires written public comments on proposed rules during a specified notice and comment period. It is known as notice and comment rulemaking or notice of proposed rulemaking, NPRM. In the formal rulemaking process, the agency rule-making process, the agency will issue notice of a proposed rule. After the public comments on the rule, an agency may move forward with the rule, revise it, or abandon it altogether. Under the APA, there are exemptions from notice and comment procedures, such as when there is good cause, or when an agency is advancing policy or procedural rules. It is important to note that the same process is used for rescinding or repealing a rule as it is in promulgating the rule. Regardless of the action, the agency must go through a notice and comment period. Technology update. Net neutrality and the FCC. In the 2010s, the Federal Communications Commission, FCC, was in the middle of a debate regarding net neutrality. Net neutrality is a concept that mandates internet service providers, ISPs, provide equal access to online content regardless of the source, platform, or user, and without favoring particular products or websites. Data online should be treated equally, and users can have access to content without restrictions so long as it is legal. Under net neutrality principles, there is more regulation of ISPs so that, in theory, underserved areas will have access to internet services as well as high-grade services and broadband connection. Enacted in 2015 and repealed in 2018, the issue has been reintroduced again in 2023 by the FCC, who has the authority to regulate these issues. The origins of net neutrality stem from rules enacted by the FCC, which barred some ISPs from intentionally manipulating the speed and access to certain websites based on individual or business demands and preferences. Think of it as the stronger, more established sites receiving the internet traffic versus less established or lesser funded sites. Although in recent years there was a deregulation of the internet, recent proposed legislation called the Net Neutrality and Broadband Justice Act in 2022 attempts to level the playing field in internet access and provide added authority to the FCC in regulating online accessibility. In short, the argument of proponents of net neutrality want to guard against discrimination online. Opponents argue that by highly regulating internet access, investment by ISPs will decrease and disincentivize companies to innovate because of the controlled regulations. It appears that the FCC has introduced the debate as of late in 2023 and intends to use its statutory as well as rulemaking authority to promote an open, unencumbered internet. It has issued a Notice of Proposed Rulemaking, NPRM, on restoring net neutrality to the internet. Regardless of the debate of net neutrality's effectiveness or goals, the FCC, an administrative agency, holds the power to promulgate rules and regulations. How this debate will turn out remains to be seen, but from an administrative law perspective, know that agencies like the FCC garner vast authority to engage and change policies that govern individuals and businesses. Real-world perspectives, on-the-job observations. For our paralegal perspective, we hear from someone who works the administrative process and represents claimants in judicial-like proceedings. Paralegal representation of a claimant in a Social Security disability hearing is the closest to a judicial setting that a paralegal may expect to become involved in. For the paralegal, this can be a very complex and challenging field. It can also be extremely rewarding, bringing with it the satisfaction of successfully representing a claimant in a quasi-judicial setting. Oberman, the Paralegal and Federal Disability Practice in Maine, MAP, newsletter, Maine Association of Paralegals. And our last paralegal perspective participated in a trial where their ingenuity contributed to a successful result at trial and was acknowledged for their hard work and diligence. It also highlights that a paralegal is a critical and valued member of the legal team and was acknowledged. It also highlights that a paralegal is a critical and valued member of the legal team and was acknowledged by their colleagues for a job well done. Rebecca McLaughlin tells of a particularly memorable event during their experience as a paralegal. It was a few minutes after 12 noon on Friday, and presiding judge Barber always recesses court at precisely 12:30 on Fridays. The government's star witness was on the stand and denied he had ever seen a certain letter. One of the trial attorneys motioned me to counsel table and asked if we had any proof that the witness had in fact seen this letter. Since there were well over 900 defense exhibits, almost 300 government exhibits, and well over 40 file cabinets filled with supporting documents, Rebecca felt little hope for success in finding out quickly. She hurried across the street to the office, found the witness's original copy of the letter with his handwritten notes in the margin, and returned to the courtroom with a big smile. The witness was impeached with his own document minutes before recess. Later, Rebecca received a well-deserved standing ovation from the attorneys and all the trial team members. It was the highlight of her career. Johnson, MALA, Spotlight. Rebecca McLaughlin, 8. The Assistant, 17. Mississippi Paralegal Association. Let this final paralegal perspective be an example of what is achievable in the paralegal profession and the rewards that come through hard work. As a paralegal legal student, strive for excellence. As a paralegal legal student, strive for excellence, and you will be rewarded in ways that are unimaginable. Not only from a job well done, but a simple thank you from someone unexpected. People do notice what you do and how you do it, so take the tools that you have learned here and other courses and get your standing ovation. Chapter Review 15-8A. Chapter Summary, Nature of Advocacy. 1. Advocacy takes place all the time. It is an everyday process by which everyone, not just attorneys, attempt to influence or change the actions of others. Formal advocacy occurs in courts and other tribunals where hearings are held to resolve controversies that the participants were not able to resolve informally. Informal advocacy occurs outside of courts and formal hearings. 2. The Administrative Procedure Act, APA, identifies two types of adjudication, formal and informal. Formal adjudication is set forth by statute and has formalized procedures. Informal adjudication varies depending upon the rights being challenged by a complainant. 3. There are 3 standards of review for administrative proceedings. 1. Substantial evidence. 2. Arbitrary and capricious. And 3. Statutory interpretation. 4. Substantial evidence is generally used in formal adjudication, and the arbitrary and capricious standard is used for informal hearings. For the statutory interpretation standard, a court performs a 2-step analysis based upon the landmark decision of Chevron USA Inc. versus Natural Resources, Defense Counsel 468 U.S. 1227, 1984. Courts must look to whether Congress has spoken on the precise question at issue. If Congress has not directly addressed the precise question at issue, the court must determine if the agency actions was a permissible construction of the statute. Informal advocacy. Advocates try many techniques of informal advocacy with varying degrees of success. The techniques are as follows. Put your cards on the table, insist on adequate service, ask to see the authority they are relying on, climb the chain of command, insist on common sense, take the role of the tired, battered, helpless citizen, cite a precedent, find the points of compromise, uncover the realm of discretion, look for an opening by asking a very broad question, demonstrate the exception, cite the law, interpret the law, be a buddy, make clear that you will fight the case, all the way up, redefine the problem, do a favor to get a favor, seek the support of third parties, preach, embarrass the official, and be angry. While using any of these techniques, you need to evaluate your effectiveness and modify the techniques based on this evaluation. Procedural due process. 1. Whenever the government takes an action that seriously affects a citizen, such as denying or removing a substantial benefit, basic fairness may require a number of procedural safeguards. These requirements are called procedural due process. 2. Depending on the seriousness of what the government is accusing or depriving you of, these safeguards can include notice, examination of the evidence against you, a hearing where you can present your case, the absence of bias, confronting your accusers, questioning, cross-examining witnesses, having representation, limiting the evidence to what is relevant, having the opportunity to present your own witnesses, receiving a decision in writing, and having an opportunity to appeal. Formal advocacy. At some state and federal administrative agencies, paralegals are authorized to provide a full range of legal services, including representation of their own clients at administrative hearings. A major example of such an agency is the Social Security Administration, SSA, particularly in the representation of applicants at disability hearings. Competent representation at such hearings requires extensive preparation and skill in marshaling facts and coherently presenting them at the hearing in light of the applicable law. State administrative proceedings and formal and formal advocacy. States also have agencies that have administrative adjudicative proceedings. Some are formal, but most are informal. The rights at stake will determine the type of hearing due process requires. Litigation support, the role of the paralegal in the administrative process. Paralegals participate extensively in the administrative process. If qualifications are met, paralegals can appear before some administrative agencies and represents clients, similar to an attorney. For paralegals who work with an attorney, they assist in many aspects of the process, from interviewing the client, preparing documents, and assisting in hearing and hearing preparation. Rulemaking authority of administrative agencies. 1. The APA provides for two types of rulemaking authority of federal agencies. They are formal and informal rulemaking. 2. Formal rulemaking entails a formal trial-like proceeding and is dictated by statute. Informal rulemaking requires only notice and comment from individuals when a rule is being proposed. From that notice and comment, a rule can be modified, accepted, or rejected. Then the procedures for their promulgation follow. Chapter Review 15-8B Key Terms: Advocacy, Procedural Due Process, Procedural Laws, Elder Law, Reconsideration Procedures, Non-Adversarial, On the Record, Battered Women Syndrome, Exhausted Administrative Remedies, Net Neutrality. Chapter Review 15-8C Review Questions. 1. What is advocacy? 2. What is the distinction between formal advocacy and formal advocacy? 3. What are the standards of review for administrative appeals? 4. What is an administrative law judge, ALJ? 5. What are the major techniques of the informal advocacy? What are the major techniques of informal advocacy? 6. What is procedural due process and why is it important? 7. Why is the distinction between procedural and substantive law? What is the distinction between procedural and substantive law? 8. Depending on the seriousness of what the government is accusing or depriving someone of, what procedural safeguards may be required? 9. What kinds of rights require procedural due process and from where are these rights derived? 10. When is a hearing non-adversarial? 11. What are the steps that a complainant can take when they are dissatisfied with an administrative decision? And where does a complainant file its challenges to the unfavorable decision? 12. What are some of the major steps a paralegal can take for effective representation of a client in a Social Security hearing? 13. How does a client exhaust administrative remedies? 14. What tasks can a paralegal perform to assist in the administrative hearing process? 15. What is the difference between formal and informal rulemaking? Chapter Review 15-8D Assignments, Critical Analysis. 15.1 In each role-playing exercise, there are two characters, C, the complainant, and E, the agency employee. Students from the class will be assigned one or the other role. In each setting, C is seeking something from E. E is uncooperative. The objective of E is to antagonize C without reason to the point where C loses objectivity. The objective of C is to use effective advocacy techniques without losing objectivity. The members of the class who are not participating in the role-playing exercises should identify and evaluate the techniques of informal advocacy that C uses. A. At 4:30 p.m., C goes to the Department of Motor Vehicles to apply for a license. E tells C that the office closes at 5 p.m. and the application procedure takes 45 minutes. E refuses to let C apply. B. C is filing a document at the clerk's office. The filing fee is $6. E tells C that the fee must be paid by check or the exact amount in cash. All C has is a $100 bill and must use some of it to take a long cab ride back to the office. C goes to the Bureau of Vital Statistics and requests a copy of their mother's birth certificate. E tells C that no citizen can obtain the birth certificate of another person without the written permission of the person. C's mother is ill in a hospital 1,000 miles away. C wants the record without going through the bother of obtaining this permission. Projects 15.2. Assume that you are working for a law firm that exclusively does immigration work. 1. Find out the process for someone seeking residency status in the United States from a foreign country. Assume that the person is married to a U.S. citizen. What forms must be filed to gain permanent residency status? 2. Is the process different if the person is seeking political asylum? If so, what is that process? 3. In both cases, residency and permanent asylum were denied. What is the appeals process for each case? 4. Outline what forms need to be filed, the hearing process, documents required, and a legal strategy for each use. Chapter Review 15-8E, Core Skills Assignments. Core Skill Writing 15.3, Using the facts from the O'Brien case, prepare the opening and closing arguments supporting Mary O'Brien's case that repayment of the SSI overpayment should be waived and would be a hardship. Core Skill Research 15.4, Using a search engine, find a list of state government agencies in your state. Pick any 3 of these agencies that publish their administrative regulations online. State the names of the regulations and their websites. Also, state whether you were able to tell how the current regulations are. Core Skill Ethics 15.5, A paralegal has set up a corporation called Paralegal Investigative Services, Inc. The company advises small businesses and assists in helping individuals get professional licenses. Paralegal Investigative Services has a deal with an attorney who assists in getting the individuals the license they seek. Paralegal Investigative charges clients a fee of $500 plus the costs of the license fee, and any paralegal investigative charges clients a fee of $500 plus the costs of the license fee and any other related expenses. Paralegal investigative pays the attorney half of the fee paid by the client. The clients do not know about the clients do not know about the attorney or have any contact with the attorney. Is that relationship ethical? What are the issues that are raised because of the professional relationship? Core Skill Computers 15.6, Identify how to set up an Excel spreadsheet for all your administrative and other cases to which you have been assigned by your law firm. Detail the step-by-step process. List the types of categories that should be included in the spreadsheet. Place that information in your computer notebook. Core Skill Collaboration 15.7, Assume that you are going to speak before a group of high school seniors On career day at the high school, you will give a presentation on paralegals and practicing before federal agencies, such as the Social Security. You will give a presentation on paralegals and practicing before federal agencies, such as the Social Security Administration and Internal Revenue Service. Not only will you talk about what paralegals are, where they work, Not only will you talk about what paralegals are, where they work, why they exist, but also the different career paths that are possible. After you present a general overview of the profession, discuss what it is like to practice before an administrative agency and how you prepare for a case before an ALJ. Write out your presentation and also include a PowerPoint to illustrate your points. Assume that your audience knows very little about the law and almost nothing about the practice of law. Be sure to avoid using any legal terms that you do not define. You want to give your audience enough information about the paralegal field to help them decide whether to consider such a career for themselves. Send your speech as an email attachment to every student in the class. For each speech you receive, send back a comment that includes 2 specific things you liked about the writer's speech, with helpful suggestions on the presentation to enhance it. The job search. 15.8. Search in Google, Bing, or Yahoo. Independent paralegal non-attorney representation agency. Find 3 websites and non-attorneys in any state who represent clients at federal, state, or local administrative agencies. Describe the services offered by each, including the agencies involved. Are the services offered different among various states or jurisdictions? Explain why the services may differ. Chapter Review 15.8. Chapter Review 15-8F. Portfolio Binder Assignment. Your supervising attorney's practice focuses on healthcare law and assists physicians, nurses, and physician assistants who are licensed. Your supervising attorney's practice focuses on healthcare law and assists physicians, nurses, and physician assistants who are licensed in other jurisdictions get a license in your state. A new client who is a licensed nurse has contacted your office about a licensure issue in your state. Apparently, the nurse was licensed based on reciprocity. Apparently, the nurse was licensed based on reciprocity. Apparently, the nurse was licensed based on reciprocity with another state. The nurse claimed to have a RN degree and took the nurse licensure exam in their home state and passed. The Board of Nurse Licensure in your state received a phone call from the hospital where the nurse was working, who claimed that the nurse did not have an RN degree. The Board of Nurse Licensure rechecked their records and contacted the client's nursing school to now find out the client did not have an RN degree. The nurse currently has a valid license from both their home state and your state. Your state wants to revoke the license based upon the failure to have a valid RN degree and fraud on the nurse licensure application. The nurse has received a notice from the Board of Nurse Licensure that a revocation hearing is scheduled for next week. Your firm has 1 week to prepare. What are the process and procedures for license revocation of a nurse in your state? What processes do the nurse? What process is due the nurse? What witnesses and evidence would be needed in support of the nurse's position? Identify the facts that your law firm needs to know to defend the license revocation. If the client loses the revocation hearing, what is the next step in your state appeals process? Outline the administrative hearing procedure in your state for revocation procedures by your nursing board. Prepare a memorandum to your supervising attorney addressing the issues posed by these facts. Place your findings and memorandum in your portfolio binder. Advocacy, the process by which you attempt to influence the goals or behavior of others. Procedural due process, the constitutional requirement that the government provide fair procedures, such as notice and an opportunity to be heard whenever the government seeks to deprive someone of life, liberty, or property. Procedural laws, the rules that govern the mechanics of resolving a dispute in court or in an administrative agency, like, for example, a rule on the time by which a party must respond to a complaint. Elder law, an area of law covering the legal problems of the elderly. Examples include Social Security, estate planning, Medicare, and age discrimination. Reconsideration procedures, a mechanism a claimant can use to challenge an initial determination an administrative agency. Reconsideration procedures, a mechanism a claimant can use to challenge an initial determination an administrative agency. Non-adversarial, pertaining to a conflict resolution proceeding in which all opposing parties to the conflict or dispute are not present. See also adversary hearing. On the record, noted or recorded in an official record of the proceeding. Battered women's syndrome, a woman's psychological helplessness or paralysis because of conditions such as financial dependence, loneliness, guilt, shame, and fear of reprisal from her spouse or significant other who has repeatedly subjected her to physical, sexual, and/or emotional abuse in the past. Net neutrality. Net neutrality is a concept that mandates the internet service providers, ISPs, provide equal access to online content, regardless of the source, platform, or user, and without favoring particular products or websites. Today is Sunday, April 5th, 2026. The time now is 3:15 a.m. Assalamu alaikum wa rahmatullahi wa barakatuh.